Do you think she's going to be on the stand again? Michael Jaafar, there have been many theories about those marks on John O'Keefe's body. They've been characterized as being part of the vehicle crash. That's the prosecution. Dog bite from the defense. And some people who have just been analyzing this case say that it could have been a scavenger animal like a raccoon or a snowplow that came along and didn't realize that he was there lying unresponsive. What are your thoughts on whether or not a jury is going to be able to utilize this testimony in a helpful way?
I'm in that camp, Julia. I'm in the camp where this is a complete misnomer, like a complete cloud of confusion. I don't see the relevance of her. I don't see why her testimony is so impactful to show that there was a conspiracy where he was killed inside the Albert's home. I think you might as well believe that Bigfoot killed him at that point, right? There's many reasons why he would have those markings. First of all, they were tested. There was no canine DNA on his arm anyway, right? It could have been a scavenger. It could have been a scavenger dog. It could have been a scavenger raccoon. But at the end of the day, does anybody actually believe that John O'Keefe died because of the markings on his arm? Football players have worse injuries on their arms, and they go back into the football game, right? Those markings didn't kill John O'Keefe. We already know from the testimony from the trial that him falling back and hitting his head on the curb would have created 1,000 pounds of force and would have been sufficient to kill him. I had a client die in April by just slipping on the stairs and hitting his head on the staircase and dying out on the spot. It happens all the time, right? So I just don't think that her testimony, and by the way, I think that this specific expert, my hunch is it will be resolved in favor of the defense. Why? The defense team is a solid team. When she walked into their office, basically when this whole thing was national fame, they sat down and they debated for days and days and days. Are we going to let this woman come into our trial? Because she was a wild card before they put her on the stand, right? And these attorneys are not the types of attorneys that would have taken a chance and had their whole case hinge on this wild card. So they were able to resolve it in their minds that she would be a good witness. So I think, you know, the process has to go out. She's going to get some pop marks. The state is going to attack her and viciously attack her because they have to do what they're doing. But I think at the end of the day, her eligibility to be in the second trial will resolve itself in favor of the defense. I just don't think, I don't believe the next jury should really put any credence into her testimony. I think her testimony, in my opinion, should be discarded by the jury for all of the reasons I just stated.
Michael, this time, what should the prosecution do differently in April that they didn't do the first time around that could actually get them a conviction?
I think the mistakes that the first prosecutor did all happened before the trial even started, right? All of them. I think that they did a really good job in the actual trial itself. The mistakes they made was denying evidence to the other side a year before the trial started. So I think what the state should do in this trial is just keep the focus on John O'Keefe, keep the focus on the injuries, keep the focus. I think they did a masterful job, right? But I think they need to keep the focus on the injuries. They need to keep the focus on the fact that this is a complete dog and pony show, that he was killed inside of the Alpert's house and brought outside. I think they should be a little sarcastic with their oratory. I think their closing argument, in my opinion, is where the money is going to be made for the state. The closing argument has to bring in the evidence that we saw. Basically, we're going to see the evidence that we saw in the first trial, we're going to see it in the second trial. I think they just need to do a more impactful job. And in my opinion, Julia, the whole entire cloud of mystery of the conspiracy hoax, I think it just wore off now. I think when we all started the first trial, even me, when we started the first trial, I was waiting to hear some pretty prolific evidence because I was promised as a viewer, you're going to see some things that are going to shock you. And what I was shocked by the things that I didn't see, which is no evidence in the 2 days that the defense had the case, no evidence of a conspiracy. Nobody stood up and said, I saw John O'Keefe come into the house and then leave, or I saw John Albert leave for an hour and come back mysteriously. I was waiting to see any of that. I didn't see any of that. I think in the second trial, the state has to highlight that in their closing arguments, that we as human beings are too dumb to cover up a crime of this magnitude with this many people. There were 10 million people in that house. Not a single person is going to testify that there was anything afoot. I mean, this is crazy. I think that's where the money is made for the state in the second trial. The closing argument has to be emphatic, and it has to ridicule the theory on the other side.
Michael, your thoughts on this case and what are some of the key things that you think the prosecution is going to use in this trial?
I think pretty much supplying drugs and fentanyl to anybody, basically you're putting yourself at risk of being indicted for murder, right? I think the state is going to focus on the fact that they were careless, that they were callous, that they basically supplied the drugs and they took the risk. The drugs were illegally obtained. They were not prescription medications. And so it's basically, it's almost the same thing as strangling somebody. And this was a grand jury indictment. And so obviously other people also agree that these charges should come down. The accessory after the fact, I'm troubled with that one, Julia, because at the end of the day, you know, I have opinions on those indictments, but David Pierce, I think he's going to be cooked, and I think he'll be found guilty. I think the state is going to focus on the fact that he supplied the drugs knowingly. They didn't break into his safe and take the drugs, and even if they did and they were legally obtained and they were invited into his house, even that might land him an indictment, but that's not what happened. He actually willingly supplied these drugs. So those are my thoughts on the case, and we'll see what happens.
Yeah, it's a difficult case for sure for the defense. And Michael Jaafar, this is a situation where we've got a man who apparently shot the girlfriend first and then the new boyfriend. If he's trying to claim some kind of self-defense, where do you think he goes with this?
I think that's the only thing he's going to do. And honestly, to be quite frank, because of the fact that he killed two people, I think that there was no offer on the table for him that he could take anyway. So I think his defense could only be, you know, I thought he had a gun. She threatened that she was going to kill me, because there's no actual audio of the actual incident. There's a video. So that would be where the defense would lie, right? In law school, Julia, they don't give us these exam questions. They don't say, hey, you have a video of a person taking out a gun and murdering two people in cold blood. They don't test us that way. They give us much more crazy fact patterns, because this is so easy. It's so like open and shut that for the prosecutors, it's just going to be, they might put the smallest prosecutor, the most least experienced one, so they can get some trial experience, because you can't lose this trial. This one is not like other trials we've covered where it could go either way. This cannot go either way. This is going to go one way. It's going to go with a conviction on both counts. His defense, I could only imagine it being something related to, he told me he was going to kill me, he had a gun, and he had threatened me before, and look at these text messages before. I was just trying to talk to them. I was just trying to buy them a drink. I was there at 7 o'clock. I didn't kill them till 10 o'clock. If I wanted to kill them, I would have killed them right away. I obviously didn't want to do that. He said he was going to kill me, and so I was defending myself. That's the only thing I could imagine it being, because either they offered him a plea, they didn't offer him a plea, in which case we have the trial, or they did offer him a plea, but he's got a wild card of a piece of evidence, something we don't know that we're going to find out in the trial. I've been surprised before, Julia. We could be surprised again.
Michael, let me start with you. I mean, it seems like a pretty much slam dunk case for the defense if you have the co-conspirator who didn't take a deal but pleaded guilty and said she didn't have anything to do with this.
Absolutely. If this is not reasonable doubt, I don't know what is. Again, I've been surprised before. We've seen cases like this. I don't want to name specific cases, but one case where the daughter said, I saw this person try, I saw my mom not do, and then the person gets convicted. So we don't know. However, with that being said, this is stereotypical, straight out of central casting, reasonable doubt, right? When the alleged co-conspirator says she has nothing to do with it and I'm guilty, it is what it is. Now, in mob trials, it's a little bit different, because the person wearing a jumpsuit is usually getting a deal, is usually getting better treatment in their facility, being moved from one facility to another, and then pointing their fingers. It's different. This is not that case. This is a case where the person who is basically serving life in prison without parole saying she had nothing to do with it. If this is not reasonable doubt, I've got to go back to law school and re-examine my definition of reasonable doubt and how I understand it. This is reasonable doubt. A juror of human beings, however, could make him, crazy things can happen, right? I've seen people get convicted with less and acquitted with more. But for me, this is reasonable doubt.
Michael, I'm striking out a bit on what I was trying to show, but that still describes what the prosecution wants to show of this woman. if she takes the stand and she's confronted with what she was doing at this memorial, what she was putting on a different kind of front for her family and friends, but behind the scenes, she's having this communication with her alleged co-conspirator, do you think that is a safe situation for her defense to put her in front of the jury?
I'm glad you asked that. I have a strong opinion on this. In the prior block, we were talking about a case, and I said, hey, you could give your least seasoned prosecutor this case so they get some trial experience because it's a slam dunk case. This case is the opposite. This case is going to require the most seasoned prosecutor you could find on planet Earth to go through this, because, yes, if she takes the stand, I think, look, every defense attorney knows their customer. They know her better than we do, right? So if she's going to take the stand, if that defense attorney feels like she can go on the stand and deliver it home, she's going to take the stand, because at the end of the day, she's standing accused of murdering her ex-husband. So I think if she can do it, if she can do it without lying, I think she should do it.